Okay, my name is Sharon Pandek. I'm with the law firm of Grehan, Taves, and Pandek. We're assisting Stafford County on some matters related to RLUIPA, and I'll tell you what that means later. I have worked with the county before. The chairman will remember that I assisted the county on matters involving the operation called Crucible when it was planning on expanding, and members of my firm have otherwise assisted the county attorney's office. With me tonight is Michael Conley, who is my associate. I may just, for fun of it with pop quizzes, turn to him and say, Michael, answer the question. So if you hear from him, he is probably as knowledgeable as I am, or if not more. Rashida McClendon is here and back in a second. Dave Honadel, Deputy County Attorney, is here, and they may also find it useful to respond. We're going to talk to you about the Religious Land Use and Institutionalized Persons Act. Thank you, Maestro. I want to give you background on that act. I want to start at the beginning and tell you, particularly because you all are on boards, commissions, or planning staff that are used to looking at pictures. And I regret to say that there are no pictures in this presentation. One of the reasons why I want to do it fairly economically. There are no pictures because we want to try to bring this to you the way that has been presented by the Department of Justice in terms of how they view the Religious Land Use and Institutionalized Persons Act, because they are the entity that goes out there and raises any issues with respect to administration of that act and enforcement. And so you have three handouts. As I said, you have the handout that's going to be your slideshow presentation tonight, which I will call the group handout. You also have the source material from which Michael and I, in large part, have taken that, which include a presentation that was done by Special Counsel to the Department of Justice, Eric Treene, and that does have pictures in it. There are pictures of other places, not Stafford County. And secondly, you have the statement of the Department of Justice on the land use provisions of RLUIPA. And I give you those because if you want to go back to the source material on the material that I'm discussing with you, you will have those available right at your fingertips. If you desire to do that, I encourage you to read all the way through it so that you might better understand this mouthful of an act. So, having said that as an introduction, let's go forward. The purpose of this is to educate you on the county's commitment to RLUIPA. The RLUIPA is a law, but Stafford County also is committed and verbally committed, actively committed to the RLUIPA being honored and administered in Stafford County. As I said, it's largely a review of the Department of Justice materials. And I always give a disclaimer. Our disclaimer is nothing in this presentation is an admission to any specific issues or statements of things that might be pending in Stafford County or in any other location. I give you the picture of the presentation. We're going to alternate between DOJ slides and DOJ statements from their statement. But I want to start first with what is really easy. And what is really easy is that RLUIPA in many ways is not new at all. Absolutely not new. And you have the Constitution of the United States. First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So this is something, religious freedom has been on the books of this country for more than 2 centuries. Okay. Then we turn to the Virginia Constitution. And again, this is a very early statement about religious freedom. And the gentleman in the back even pointed me out to rather arcane language in describing religious freedom in Virginia, if you read all the way through this. So religious freedom and the free exercise of religion has been a given in Virginia for a long time. I want to take you to notices that you will see with respect to the statements that Stafford County has made regarding non-discrimination across the board. And I'll read it because I think it's important. Stafford County treats all applications and applicants equally. The county does not discriminate against religion or on the basis of race, sex, age, national origin, or disability. In its planning, permitting, utilities, and land use processes, Stafford welcomes all. Pretty obvious, pretty simple, and across the board. You will see that not only on the Stafford webpage, you'll see it signs in the permitting center and the utility customer service counter. Stafford County also includes an insert in land use applications. And I want to point you through this with some specificity because I think it's important. The first is pretty much like the notice you've seen already, that Stafford does not discriminate. Secondly, the notation that under the laws of U.S. and the Commonwealth, there is no discrimination. You've already seen those two constitutional amendments. Thirdly, under the Religious Land Use and Institutionalized Persons Act. And if you get really to a strong understanding of this, you can roll off RLUIPA off your tongue without even thinking about it. But it's a little hard to do that at first. Under RLUIPA, no government may apply its zoning or land use laws in a matter that unjustifiably imposes a substantial burden on religious exercise. A short statement of what RLUIPA is. We'll talk about that some more. Next, it also provides that no government may apply its zoning or land use laws that treats religious assemblies in unequal terms with non-religious assemblies. Next, that RLUIPA provides that no government may impose or implement a land use regulation that discriminates against a religious assembly or institution. And then finally, again, that Stafford does not discriminate and treats all applications equally. So having turned from that introduction, I want to take you to RLUIPA itself. Congress found, when it first reviewed this issue back in 2000, what it termed to be massive evidence of widespread discrimination against religious institutions by state and local officials in land use decisions. I might note that at least when I went through some of the legislative background on that, I did not find mention of Virginia or Stafford County. So I just want to point that out to you. They weren't specifically calling out Virginia, but they found that. What is interesting is that this bill passed Congress in about a week. Now, if you think about all the things that are going on, that's pretty amazing. It was co-sponsored by a Republican and a Democrat, and it had virtually unanimous approval. So let's turn to some of the other things that at least Congress called out. That minority religious groups were being disproportionately affected, that Christian churches with minorities memberships were being disproportionately affected, and that zoning codes frequently excluded churches where they permitted theaters, meeting halls, and other places where there were large groups of people who could assemble. The distinction between religious and non-religious. So they adopted this act, enacted it in 2000, and said the right to assemble for worship is at the very core of the free exercise of religion. Churches and synagogues cannot function without a physical space adequate to their needs and consistent with their theological requirements. And there you see the two patrons of the bill, Senator Hatch and Senator Kennedy. Signed into law in 2000, it created a private right of action, and we'll talk a little bit about that more, that a religious assembly or institution can file suit. The Department of Justice, and that's why I've given you these materials, has the specific ability to file suit for injunctive or declaratory relief to enforce compliance with that act. Okay, we're going to drill down into this a bit, and again, you're going to see lots of words, and I'm going to try to take you through this pretty quickly. There are essentially 5 protections that appear in RLUIPA, and most of this discussion I'm going to have with you today revolves around those protections. The first is protection against substantial burdens on religious exercise, unless there's a compelling governmental interest, and we'll talk about that more later. Second is protections against unequal treatment for religious assemblies and institutions. That is compared to non-religious assemblies or institutions. The third is protection against religious or denominational discrimination. If we go to the next page, fourth is protection against total exclusion of religious assemblies from a jurisdiction. And then finally, protection against unreasonable limitation of religious assemblies within a jurisdiction. Who is protected by RLUIPA, and what types of activities are protected? And again, you'll note at the bottom of these slides where I've taken excerpts from the Department of Justice statement. It protects religious exercise of persons, which includes religious assemblies and institutions, not just individuals. And then some examples of what it's been used to protect. Houses of worship, individuals holding prayer meetings in their homes, religious schools, religious retreat centers, faith-based homeless shelters, soup kitchens, group homes, and other social services. And I recall when I was advising the Fairfax County Board of Zoning Appeals, some of these types of issues came up in the applications before the BZA. What does religious exercise include? It includes exercise of religion, whether or not compelled by or central to a system of religious belief. And you go, well, what does that mean? And there's an example in the second paragraph. That it can't be simply because a religious group wants to do something rather than something it must do that allows the local government to regulate. So the example is a town could not claim that a Wednesday prayer meeting was not a religious exercise because they were less central to the church's beliefs than the compulsory Sunday worship services. So localities cannot begin to exercise regulation in making those kind of distinctions. Religious exercise covers a wide range of activities, including, and we listed some before, homeless shelters, soup kitchens, social services, accessory uses such as fellowship halls, parish halls, similar buildings used for meetings, religious education, operation of a religious retreat center in a house. We referenced religious gatherings in homes, and construction or expansion of schools, even where the facilities would be both for secular and religious activities. Who is bound by RLUIPA requirements? It includes states, counties, cities, towns, villages, city councils, zoning boards, zoning appeals boards, planning commissions. It does not cover the actions of private citizens unless they're acting under color of state law, such as governmental employees. It does not apply to the federal government, although there's another act that relates to the federal government. How do you define land use? It covers zoning and landmarking laws. So what is a landmarking law? To my knowledge, landmarks appear in the Code of Virginia, but not landmarking laws. In some places, that is a reference to zoning laws and the application of zoning authority, in addition to noting sites as being such as an historical landmark. But we're looking at this primarily in the zoning context. It does not, however, include other laws that touch on real property, such as fire codes, landlord-tenant laws, local civil rights laws, and tax laws. It applies to any land use regulation. Let's drill down on this a bit and see what that means. Again, we have the reference in the law to zoning or landmarking law that limits or restricts a claimant's use to development of land. Sounds like zoning regulation. Zoning law encompasses laws, ordinances, codes that determine what type of building or land use can be located in what areas and under what conditions. Landmark preservation laws are restrictions that municipalities place on specific buildings or sites to preserve them if they're deemed significant. RLUIPA's definition of land use regulation does not extend to every type of law involving land, and we already touched on that a little bit. Doesn't include fire codes, doesn't include ordinances requiring municipal sewer connections. I mentioned taxes already, landlord-tenant, laws governing trespass. That's just a small microcosm where it does not apply. As a general matter, RLUIPA doesn't apply to the exercise of eminent domain or condemnation law. However, there are cases where municipalities have tried to use eminent domain to short-circuit the zoning process for places of worship that applied for zoning approval, and the courts have found that such actions may be covered by RLUIPA. I say may, and you go, why may, maybe not? Some of the cases that are out there ultimately are settled. And so while the court may have dealt with a case that involved eminent domain, it may not have ruled on the issue as to whether eminent domain actually was covered by RLUIPA, but the parties otherwise settled the matter. Can places of worship still be landmarked? Yes. However, if it imposes a substantial burden on religious exercise, you have to justify it by compelling governmental interests, and do so by the least restrictive means. You also can't discriminate. And I mention that because there was a church, as I recall, it was an Orthodox church in Pennsylvania in which the issue of landmarking came up, and the issue arose as to whether or not there was discrimination under RLUIPA. Does RLUIPA exempt religious assemblies and institutions from local zoning laws? No. The answer is no. It is not a blanket exclusion from zoning laws. Religious institutions must apply for the same permits, follow the same requirements, go through the same land use processes as other land uses. It does not preempt or replace the normal zoning code. That's important to know that. Rather, it imposes safeguards and requirements on local governments regarding zoning that impact religious uses. And then there are 4 items bulleted in green on your slides, and they cover essentially the things that I talked about at the beginning regarding RLUIPA, but I'll go through them again. That the zoning law doesn't substantially burden religious exercise without a compelling justification, and talk about those aspects further. That it doesn't treat religious uses less favorably than non-religious uses. That it doesn't discriminate based on religion or religious denomination. And that it doesn't totally or unreasonably restrict religious uses. Importantly, when there's a conflict between the zoning ordinance and how it's applied and RLUIPA, the RLUIPA law preempts, takes precedence over the zoning ordinance. So federal law in this case takes preeminence and the local zoning law gives way. Again, importantly to know, as long as a locality applies its codes uniformly, does not impose unjustified substantial burden on religious exercise, it can apply traditional zoning regulations and concerns. And there's some examples here: traffic, hours of use, parking, maximum capacity, intensity of use, setbacks, and frontage. have been held to apply to religious uses just as they are applied to any other land uses. I should note as a caveat, however, that if there's a determination that there is not a compelling governmental use arising from some of these regulations, that a court may find differently. So you have some courts that have upheld what I've just told you. I think that's the Department of Justice is included in there for that purpose. But there are others that have suggested that some of these need to be demonstrated to be compelling governmental interests. Are there occasions when a religious assembly or institution does not have to apply for zoning approval and appeal any denial before it has recourse to RLUIPA? We call this sort of exhausting your administrative appeals. There's an important case before the U.S. Supreme Court years ago called Williamson that said you have to exhaust administrative appeals before you can pursue other actions. And as a practical matter, the answer is yes, but not necessarily. The Department of Justice has noted that when there are applications for zoning permits, special use permit, conditional use permit, special exception, that it is often the fastest and most efficient way for a religious institution that is applying for some specific use or permit to obtain approval. And the Act encourages, as does the Department of Justice, that there be a local resolution of disputes. And that's why you won't find in as many cases, perhaps, in which there are ultimate decisions on RLUIPA because a number of them settle. And then we should note that in some circumstances, the courts have held that religious institutions don't have to make an application or appeal before filing a RLUIPA lawsuit, where that application or appeal would be futile, or where there's would be excessive delay, uncertainty, or expense, or that the application requirements are discriminatory, that is legally discriminatory, versus non-religious uses on their face. And I recollect a case, some states from here, in which applications were going up over a period of 12 years. And the court said, you know, this clearly you don't need to apply anymore before you come and sue in court. Okay, two basic provisions that we'll focus in a little bit more. One is substantial burdens. What are substantial burdens on religion? And secondly, discrimination and exclusion. Turn to substantial burden. The Act and the references here to sections are from RLUIPA. The government cannot impose a substantial burden on religious exercise of a person, including an assembly or institution, unless the government demonstrates that the imposition of the burden is in furtherance of a compelling governmental interest and is the least restrictive means of furthering that compelling governmental interest. What is a substantial burden under RLUIPA? It's got to be more than an inconvenience on religious exercise. The group doesn't have to show, however, that there's no other parcel of land on which it might build its facility. And it's very fact-intensive. When courts have studied the issue of substantial burden on the matters coming before it, it's looked at the severity of the burden on the group's actual religious exercise. So that's important, burden on religious exercise. What kinds of burdens on religious exercise are substantial burdens under RLUIPA? As I noted, it is fact-intensive, and it looks at the degree that the restriction is likely to impair the ability of the person or group to engage in the specific religious exercise. It depends on context. So I listed a few things that the Department of Justice has noticed and noted in terms of context. the size and resources of the burden party, that is the religious institution, the actual religious needs of the individual or the institution, the level of current or imminent space constraints, somebody in a very tiny church with thousands of parishioners looking at a larger space, whether alternative properties are reasonably available, a history of the complainant's efforts to locate within a community. I cited to you one example where a religious group had been looking for a period of over a decade. Absence of good faith by zoning authorities. There certainly at times are people who say things about religious groups that are quite negative and obviously negative when they're said or written, and that's something that the court may look at, and other factors. We'll take some questions then, if you don't mind, because I want to make my 45 minutes. When a municipality takes one of the following types of actions, it could be a substantial burden. And I use county sometimes, I use locality, I use municipality. Barring the use of a particular property for religious activity, imposing a significantly greater restriction on religious use of the property, or creating significant delay, uncertainty, or expense in constructing or expanding a place of worship or other religious facility. Examples are in the second paragraph: denial of a church construction permit due to onerous off-street parking requirements, a permit condition requiring a religious retreat center to operate as a bed and breakfast, a denial of construction of a parish center, a denial of expansion plans for a religious school, and denial of ability to convert a building storage space to religious use. However, the flip side is that courts have also found no substantial burden when a church was denied the amount of off-street parking it would have preferred, while there were other reasonable alternatives available they didn't pursue. When a religious high school was denied the ability to operate a commercial fitness center and dance studio. When a church was barred from demolishing an adjacent landmark building it had purchased to construct a family life center, as there was no other space on the church's campus that was suitable. So you can see it's highly, highly fact-specific. When does the substantial burden test apply in a particular case? When the government makes individualized assessments of the proposed uses of the property involved. That's important, an individualized assessment. But by their nature, some zoning decisions do involve individualized assessments, and we mentioned some of those. Variances, special use permits, special exception permits, rezoning applications. All of these ordinarily involve the government reviewing the facts and making discretionary determinations whether to grant or reject an application. Denial of a building or occupancy permit based solely on mechanical, objective basis, with no discretion, however, would not be considered under the substantial burden test. Again, satisfying the substantial burden test by a religious institution is only half of it. The local government can still show that there's a compelling governmental interest. Finally, even if a zoning case did not involve an individualized assessment, the substantial burden test still applies if the use at issue impacts interstate commerce, if there's federal funding involved. So that's a different aspect of this. What are examples of compelling interests that would permit the local government to impose substantial burdens on religious exercise? Can't do it unless you consider also are the means the least restrictive of religious freedom possible. Compelling interest is a legal term, meaning interests of the highest order. Governmental interests that are merely reasonably or even significantly important are insufficient. So courts have ruled, and again, this is very fact-specific, that municipal interests in revenue generation, economic development, or eliminating congestion are not compelling. But the burden of proving what is a compelling governmental interest is squarely that of the local government. Ones that have been found to be compelling, however, are preserving public health and safety, and in some cases relating to traffic. On the traffic issue, since that's one that comes up fairly frequently, particularly in congested areas, you can't rely on it as an abstract compelling interest. You have to show that interest through the particular restriction at issue, such as safety interests regulating traffic flow on a particular street at issue. So I recollect years ago there was a situation in a county that I advised in which there was a church that was going to locate off a major highway. It couldn't get an access right onto the highway, and it was going to run what would have been estimated to be 900 cars through residential streets in a single subdivision. That matter fortunately never became explosive. It was worked out, but that would have been a situation in which the locality might well have been able to show a compelling governmental interest with all of that traffic sort of unpredictably now going through this very narrow residential subdivision street. Again, though, you have to look at the least restrictive means of imposing it. If there's another way that the government could achieve the same compelling governmental interest, that it would impose a lesser burden, then that would have to be pursued. Equal terms and non-discrimination. This also comes from the Act. No government shall impose or implement a land use regulation that treats a religious assembly or institution on less than equal terms than a non-religious facility. Seems pretty obvious. What does RLUIPA say in more detail with respect to that? No government shall impose or implement a land use regulation in a manner that treats a religious assembly or institution on less than equal terms with a non-religious assembly or institution. Kind of just what I told you, pretty obvious. Congress included this, however, to address problems of zoning codes where they exclude places of worship but allow secular assemblies. Again, I gave you some of the examples earlier: theaters, meeting halls, private clubs, etc., which are allowed, but the argument might be that a church would have an equal number of people coming to them and should not be allowed. Determining if it's in fact being treated as less than equal terms, again, requires a comparison, very fact-specific. Courts have differed on how this comparison is made, and so the legal test is not as clear as it might be. And so one of the problems that we have in the RLUIPA area, because it is so fact-specific, is that you sometimes have the feeling that what we're telling you is maybe all in a gray area. That's because sometimes courts have decided one way, sometimes courts have decided another way based on the particular facts. Courts have found the equal terms section violated in situations where places of worship were forbidden, but private clubs were allowed. And again, in paragraph 3, there are other examples of this where looking at things like occupancy, amount of traffic, you have equivalences, and the zoning ordinance allowed one, didn't allow others. The fourth paragraph offers how to avoid that, and that is you focus on the external factors, impacts, such as parking, intensity, traffic, hours of operation, noise, etc., and you treat the religious and non-religious institutions equivalently. Let's turn to non-discrimination a bit further. Prohibits intentional discrimination. In this case, there's no requirement for comparison to another assembly. And I note, and this is the Department of Justice slide, they refer specifically to Muslim cases being particularly active when this presentation was made. If you look back through other sections of history, you will find that different types of religious institutions have from time to time taken up court's attentions in different phases. What constitutes discrimination based on religion or religious denomination under RLUIPA? Again, references to the specific sections of the Act, barring discrimination of implementation as opposed to just the statement itself in the ordinance or code. So you can't apply laws in ways that discriminate against religious institutions under RLUIPA. So if you look at the second paragraph, if a permit is denied because town officials do not like members of a particular religious group or the religious group, or for any other reason that reflects on the religious group and suggests that if it was not this particular religious group but another one, we would have granted it, that's a violation of RLUIPA. And also in the third paragraph, we note that it can refer to a subsect and not just a particular religion. So it could be a sect of that religion. That also triggers a violation of RLUIPA if there's overt discrimination or discrimination in implementation. Okay, unreasonable or total exclusion. You can't totally exclude any religious assemblies from a jurisdiction. And you can't unreasonably limit religious assemblies, institutions, or structures within a jurisdiction. And there, the Department of Justice cited a couple of cases. What does it mean for local government to totally exclude religious uses? That is saying there is no location that you can be here to a religious institution. Don't have any place in our jurisdiction for you. That would be an obvious violation of the Act. What does it mean for local government to impose unreasonable limitations? Again, with references to the Act. It's if the locality's land use laws deprive religious institutions and assemblies of reasonable opportunities to use and construct structures in their jurisdiction. Again, this is very fact-intensive. It includes looking at the availability of land, the economics of religious organizations, and courts have looked at such things as where regulations effectively left few sites for construction of houses of worship, such as through excessive frontage and space requirements, or have imposed steep and questionable expenses on applicants where they didn't apply those to non-religious applicants. What can a local government do to avoid liability under RLUIPA? RLUIPA does have a safe harbor provision that protects a local government from application of its enforcement provisions if it takes steps to ameliorate, mitigate, remove a violation. And it can therefore avoid the forces of RLUIPA provisions. Some other examples of how the Department of Justice suggests that: changing the policy or practice that results in a substantial burden on religious exercise, retaining the policy or practice and exempting the substantially burdened religious exercise, providing exemptions from those applications that are suffering this substantial burden, and again, the last focus on eliminating what is called or deemed to be a substantial burden. Okay, who do you contact, or who does someone contact if they believe that RLUIPA is being violated? With respect to Stafford County, the encouragement is that you advise county staff of any concerns or complaints, and Mr. Harvey and Mr. Towery are the individuals who should be contacted. The county administrator or the deputy county administrator will then investigate the matter and talk to the complainant in order to resolve that complaint. We also have included, which Mr. Treene did as well in his presentation, the contact information at the Department of Justice Civil Rights Division Housing and Civil Enforcement section. Before concluding, I want to go back to where we started, which is what Stafford County has made very clear, and that is it does not discriminate. We can call this the Stafford County RLUIPA notice, but it goes beyond that, and it's a statement that the county does not discriminate against religion or on the basis of race, sex, age, national origin, or disability in its planning, permitting, utilities, and land use processes, and that Stafford welcomes all. I'll leave you with those thoughts. Michael and I would be glad to answer some questions in order to try to elucidate this. I know that this has in some ways been a little tedious, maybe a little repetitive, and part of the repetition I think is useful because you can get more comfortable with an understanding of what RLUIPA is about. It is important. You all have a lot on your plate as to the important laws you have to enforce, but Rashida and I thought it would be very important for you to have a briefing on this so that when somebody comes in and says RLUIPA, you don't kind of go, what? And remember, if you can't remember what the initials stand for, remember it's religious freedom that is first and foremost guaranteed by the Constitution of the United States under the First Amendment. It's guaranteed by the Virginia Constitution. And so RLUIPA has more detail, but you already know. And you should have known this since high school, if not before. You already have that embedded in you, and that's what Stafford County is about. As I said, I'll be glad to answer any questions. I think this gentleman asked first. Yes, yes. Okay, go ahead. Yes. Oh, that's the biggest challenge I'll have. Let's go back to it. No, I think that's easier.
That long paragraph, you talk about other secular assembly places. Can you define that a little bit more? Like a restaurant?
Yes, it could be. It could be, sure. A restaurant could be. And if you're comparing it to a church that's serving meals for the poor or otherwise, then it might well be a comparison. Yes. So you need to, if you haven't thought about it in those contexts, it is useful to sort of do a little mind bending and say, okay, what are those things that the religious institutions with which I am familiar, either because I attend one or because I have encountered information on them, what are the various aspects of those? And then are there any things that are equivalent to them that I see out there in the non-secular world? And that's what RLUIPA begins to talk about. It's fairly easy to see how they can be viewed as equivalencies if you have, let's say you have a concert hall, and you say, well, if I've got a church that also holds 1,000 people, then I need to be looking at some similar things in terms of traffic, maybe noise, depending on concerts, occupancy, size of building, those types of things. So you begin to look at those. I'll give you an odd, since I just came to mind, an odd situation where it mixed the two, unfortunately, and the issue was worked out, in this case, by common sense. There was a religious institution, it was a Presbyterian church, I believe, that wanted to bring in a tent to have its services under the tent in Prince William County. While it was building, it was planning and building its new facility. Hadn't come out of the ground yet with a new facility. And they had borrowed this tent or bought it from a Presbyterian church out in Arizona. Well, there are building code issues now that you've triggered when you get into that, not just the land use siting issues. And the situation becomes very different because whereas a tent might well hold up pretty well in Arizona, a tent in Northern Virginia of the size that might, house or cover several hundred people, has very different implications. And so then you get into issues: is it a building code issue? Is there a compelling governmental interest, which might be the safety of the parishioners? And how does that counter against the fact that the church says we don't have the money to put up our brick and mortar structure right now? So that wasn't your question, but I just passed it along as kind of an interesting sort of, you look at the dynamics. Yes, sir.
Talking about government interest, and you mentioned traffic safety. Is there anything, any interpretation of RLUIPA that would compel the government to take some action to improve traffic safety conditions in order to allow this sort of exercise? Suppose it required installing a new traffic light. Does the county have to pursue that at their expense, or can they impose that on the church or organization that wants to build there and say you can't build unless you do it? Because we're having this problem with the properties right now, where we can't hardly tell anybody to do anything.
That's another program that would take more than 45 minutes. So let me tell you, the answer to that is going to be very context specific. I think to the outside observer, requiring the locality to put in a traffic light would seem like not much. Now, I haven't asked about the cost of a traffic light recently, but the last time I asked, it was upwards of $100,000. And maybe it's probably more than that, because that's at least 5 years ago. So you have to look in context then. Is that a de minimis burden? It is on the locality at that point. And are there other alternatives? So I think you have to look at what the traffic situation is, and then how much of a problem is it? Is it a few people being added to that particular intersection? Or is it a lot of people? And what are the various alternatives that the locality has if the religious institution is going to be there? And that's the type of analysis we went through when I described to you the situation about a religious institution that wanted to build on a major highway, and VDOT said, you're too close to a light for another curb cut. And the only alternative seemed originally to go through this residential neighborhood, which would have been a huge impact. Now, ultimately, I recollect that there was another access found, and therefore that was deemed to be not a substantial burden to have that church use that other access. So it's I can't sort of take it abstractly and say that the locality has to step in and do that. I think you're going to have to look at it in context.
Does the burden fall back to the locality, or does the locality say a traffic light is needed if you're willing to pay for it, church XYZ? Or does the locality have to assume that financial burden?
I understand what you're asking, but I think you have to first look at, is it a substantial burden on the religious institution? A lot of our religious institutions are not little village churches. And so that's the first analysis. And then you look at how bad is the situation. You look at what are least restrictive alternatives, if there are any. And then you reach the conclusion as to whether a new traffic light is the answer and how does that occur. So I did have my timer on to get me to be quiet. So I can't give you the precise answer on that. And I do hate to tell you this. Rashida will thank me, though, that taking abstract questions and giving you a definite answer would be wrong, because you're going to have to go back and talk, if depending on whether you have separate outside counsel, if you're the BZA, or you're the planning commission, you're going to consult with the county attorney's office directly or indirectly and on those specific facts. These are in many cases very, very fact specific. You don't have the easy ones anymore saying we don't want no Catholics here. And I can say that because I'm Catholic. Those types of situations are extremely rare in terms of the clear RLUIPA issues. It's the more fact-intensive ones. Yes, ma'am.
I have two questions, actually, and I could not find it in the slide.
Okay.
I think you said that religious groups still have to go through the standard process like everyone else.
That's correct.
As far as the application procedures and follow.
Correct.
No special door for them to go through, right?
That's correct.
Okay. And my second question was on slide 27.
Michael, you want to get that number on the slide so we can tell people?
It was about substantial burden under RLUIPA.
I'm sorry, what slide are you on?
27.
Okay. All right.
Okay. Okay, the middle bullet, a group need not show there is no other parcel of land which it might build.
Right.
So they don't have to show that. But on the next page, on 28.
Mm-hmm. Yes, I tell you factors, and one of which is yes. Okay, let me give you an example. There may be a situation in which a religious group might say that we have this parcel of land and there's a violation of RLUIPA occurring with respect to that. There may be a situation in which a court says, okay, you can bring a lawsuit under that, we'll at least consider it. And the court may actually find there is a violation without reaching this other point as to whether there are alternative properties. But I would say to you that if there are a lot of alternative properties available, the first argument is probably not going to be the one that succeeds.
I just want to make sure it's in the context.
It does, and that's a good point. No, I think it's interesting. And again, it becomes very fact-intensive. If you'll note, it says need not in there, doesn't show, doesn't have to show. It says need not. And in this one, it shows whether alternative properties are reasonably available. So it's going to be fact-intensive on that.
Okay, so
I would say to you that if there,
one other property available probably wouldn't help if there was a
right,
property.
exactly, right.
Okay, that was my two
Right,
questions.
yeah, that's a good point for asking that. I'd like to remain internally consistent. These actually both came from the Department of Justice report. So, yeah, all lawyers. Yes, no. We all kind of like give confusing advice at times. So I think they're reflecting what the courts are. In some cases, courts have said, you don't have to go out and look and survey the area. In other cases, they've said you should know there are all these other properties available. Why should there be why should you get exempted here? Any other questions? Yes, sir.
Look at page 14, the second bullet. So, does RLUIPA or some statute or code section refer to or define what is a structure under RLUIPA?
Michael, I don't recall there being a definition that is across the board definition. Yes, he's confirming it. He's surveyed the RLUIPA cases for me. No. You did see the one case that they mentioned about converting a building into another use. So that was a storage building.
That building is, at least in common sense terms, a structure.
That's correct. Yes, a fence could be a structure. Can't think of immediately right off of any case I've seen in which fences were an issue. But buildings are pretty obvious. Yes, sir.
On the bottom of page 23.
Oh, you all are really reviewing these. Thank you.
They talk about an unjustified substantial burden.
Mm-hmm.
Could you talk more about what unjustified is? That goes to compelling interest of the
Right,
owner?
exactly.
Is that what that refers to?
Yeah. Yes. Any other questions? Yes, sir. If you're going into Old English again or Old Virginia English, you've bested me already. That's great. Thank you. Oh my gosh. Have you ever heard of the Church of What's Happening Now? You have to have a fervent belief in a religious or in a what could be a religious view. And there's a recent case, and I've forgotten the name of it. Michael, you may, but it basically is about the Church of What's Happening Now. And the court found that there was no truly fervent belief in this particular view, that it could not in any way be deemed to be the equivalent of a religious view. However, there are a lot of cases out there that indicate that what we might consider to be mainstream religious views and institutions courts are not going to limit themselves to it. You will find a case with respect to the smoking of peyote by Indians that is considered to be, by them, a religious event, American Indians. There are the religious practices of, I'm going to get the name wrong, I apologize for that, the Santa Marias, in which there are chickens that are killed in ritualistic manner as part of their religious practices that have been protected. No, sir. No, sir. Nope, you don't have to demonstrate that. That would be helpful if one is trying to demonstrate that one has, if it's a sort of edgy religious view. It would be helpful to have those things, perhaps, to demonstrate to the court that it is a strongly held religious-like belief. But there have been what are truly, I think, one would call the more edge views that courts have sometimes found to be religious views. But there is a recent opinion on what, it's not called the Church of What's Happening Now, but basically the court said that this person did not demonstrate that this was a truly held religious belief. And I apologize for not bringing that case. I'll be glad to send it to Rashida, and she can tell you if you want to hear it. Any other questions? We appreciate your time, and I would, I sometimes say send me a message if you have other questions. I'd prefer that you not do that, just because it allows Rashida and Dave to sort of make sure that everybody's informed. So if you have a question that we haven't answered that you think is really important, then for those of you who are on the Board of Zoning Appeals, I understand sometimes you have outside counsel, but for the rest of you all that consult generally with County Attorney's Office, send those to Rashida. Does that sound okay, Rashida? Yeah, I'd rather not sort of like be passing out individual pieces of advice. I think that's not useful in terms of, I didn't pick on you, Jeff. I could have them send it all to you. No, that's fine. Yes, sir. Yes. Actually, I think it does. Have you looked at that, Michael? I believe it does. It's primarily refers to jails, though. So, and there have been issues with people practicing religious beliefs in jails that have sometimes been issues of difficulty, dietary constraints, some other things of that sort. Times to to engage in religious prayers. And so it's odd on one hand to have it say land use, and then have it also relate to institutionalized persons, but that's the way the act came out.
Just a question. How many cases are usually that are brought for RLUIPA or dismissed?
Oh, I don't know. I don't know the answer to that. I can tell you that as we've read through the cases, that a number of them are brought and then are resolved. Yes, or in court or otherwise. I will tell you, in Virginia, there have been relatively few cases that have ultimately gone to trial. Michael and I handled a matter for Culpeper County about a year and a half ago, and that case never went to trial. It was ultimately dismissed for mootness, but the county did work out part of the situation with the religious institution. Mm-hmm. Oh, that's a good question. No, there are not many that I can think of that have gone to trial in Virginia. Okay, we're 2 minutes over, so I'll be glad to stay for a little while afterwards if you have any other questions. Rashida's here, Dave Honail's here, and thank you very much for your time. Have a good evening. Drive carefully.